Good afternoon, everyone, and welcome to our webinar today, Supreme Court Preview, What to Expect from the 25-2026 Term. I am Jessica Werman. I'm the Managing Editor of Politics and Leadership at CQ and Roll Call. This webinar is hosted by Fiscal Note, our parent company and the home to Policy Note, Voter Voice, and more. Fiscal Note empowers the world's leading organizations with critical insights and the tools to turn them into action. To learn more about Fiscal Note and our family of brands, visit fiscalnote.com. Before we begin, a few housekeeping notes. We will be recording this session and we'll share it with you via email later this week. We also encourage you to submit your questions in the Q&A box at the bottom of your Zoom window. Today, we want to talk about the upcoming Supreme Court cases and potential policy ramifications. The U.S. Supreme Court starts its new term October 6th with a stack of cases that could reshape the legal, policy, and election landscapes. Moderating this discussion today is Todd Ruger, the editor of legal affairs for CQ and Roll Call. He will be asking Michael McEnany, the legal affairs staff writer for CQ and Roll Call, for his take on the coming term. Welcome, guys.
Hi.
Hi, thank you, Jess. Jess, welcome to the thing that Michael and I have been, all the trenches that we've been in for years covering the Supreme Court. I covered the Supreme Court here for a few years before becoming an editor over legal affairs, and Michael is now covering the Supreme Court, which, as everybody attending here knows, has been a vigorous beat in the last few years, momentous decisions. And one of the ways in which I think policy is getting decided more and more. And so I do think it's really important to pay attention to what the courts are doing, particularly with how it affects Congress and legislating and funding even this year, how it affects the government operations, and there's huge cases. So thank you, Jess. Welcome, Mike. And Mike and I have done a few of these, and as he knows, I always like to start out a bit to set the table on everything, where we are, how we got here. I think that's particularly useful this term because of the justices didn't get much of a summer. So, Mike, what went on at the close of last term and over the course of the summer?
Yeah, so close of last term, we got, the usual ream of sort of blockbuster decisions on things like limiting lower courts on nationwide injunctions in the birthright citizenship case. I'm already getting tongue-tied. Upholding limits for states on transgender, gender-affirming treatment for minors. The limits of the First Amendment in the context of pornography online. There was the Medicaid funding case for Planned Parenthood in South Carolina. Preventive Care Task Force under the ACA was upheld. The court also upheld the FCC's E-rate program and restricted the scope of National Environmental Policy Act reviews. Long list of things in addition to all of what I'm going to call the Trump stuff, which was emergency docket decisions on immigration, on firing officials, on firing, generally line government employees, dismissing transgender military members, whether or not people can be deported with due process. Huge number of emergency docket decisions that has exploded as an activity of the court in the last year. So very, very busy end to the term this summer that has only continued in July and August.
Right, and just to clarify there, the emergency docket is basically, some people call it the shadow docket. It's where cases reach the Supreme Court at a preliminary stage and are decided with fewer formalized procedures, frequently on a shorter timeline. And these are increasingly becoming part of how the Supreme Court is doing business. And so they usually take a break between the terms. I think it's fair to say, with all those decisions that you listed there, that the court continued moving in a conservative direction with the 6-3 majority that it has of conservative appointees. And so then usually they take some time off during the summer, but there was this emergency docket stuff. So what happened over the summer and how did that set up this term?
Yeah. So there were several big emergency docket cases that emerged over the summer, uh, and that have also set up now for merits cases this term. But the two biggest emergency docket cases were VOS elections versus Trump, or learning resources versus Trump, which are the two big cases on Trump's, Liberation Day tariffs. We're going to be talking about that in a little bit, as well as Trump versus Slaughter, which is the removal of one of the Democratic members of the Federal Trade Commission, um, uh, ostensibly without cause. That is going to be the big removal case this term. There's also, pending emergency cases over the removal of the Federal Reserve member Cook from her position, and disputes about whether that was for cause. Some very, very big emergency docket things there. There's also, as of the start of this webinar, I have not checked my email in the last 10 minutes. As of the start of this webinar, the Supreme Court has not issued a ruling on the biggest spending emergency case to emerge so far, which is over the legality, constitutionality, whatever amorphous decision they decide to come down on Trump's attempted use of pocket rescissions through the Impoundment Control Act. We can get into that a little bit later, but that is a lot of big decisions that are de facto deciding American law that are happening very quickly compared to the normal court process where it can take months or years to work its way through the courts. Now this is happening over the course of days or weeks.
Right, and what you mentioned there is that some of these emergency docket things have now translated into actual docket cases, and they're going to hear them quickly. It does seem like last term it was they took some cases that were big culturally and politically, but they also left some spots on their agenda because they knew that there would be some Trump some Trump cases coming down as he was doing some things, and that turned out to be the case. Was probably half their stuff, and it appears that might be happening again this term. So as Jess mentioned, they start the first Monday in October, October 6th this year. So what do you see as the broad trends and your thoughts as this approaches? Conservative court, Trump in office. What are you watching for and looking for?
Yeah. So with the caveat that there's only been 38 cases granted so far for 34 arguments, there are almost certainly more coming. Generally, I see the big cases in three buckets. The first being presidential power. I already mentioned the tariff and removal cases are sort of the biggest high points on those. The second being a trio of election cases. Dealing with redistricting, limits on campaign spending, who can fight over post-election day ballot counting, and then also sort of the culture war, which is a trio of LGBT and First Amendment right cases that are also going to be heading to the court very soon for argument.
Okay, well, let's dive in then. I think the biggest one in my mind is the tariffs case. So what can you tell us about when that might be argued and what's at stake and who the sides are and all that?
Yes, so this is another one of those emergency docket cases that's moving very quickly. This has already been set for argument in November. And fundamentally, this is a dispute over whether or not Trump has the power to set his own tariffs by declaring an emergency and sort of charging whatever he wants, which is kind of the DOJ's argument in this case, that there is a 1977 law called the International Emergency Economic Powers Act. I think that is the the name of it. The acronym is IEEPA. Gives the president the power to regulate trade in the course of a national emergency. The DOJ argues that regulating trade includes charging tariffs. Two lower courts disagreed and said, no, these tariffs are illegal. DOJ has asked the Supreme Court to weigh in and say that these tariffs are in fact legal. This is a huge case in terms of the amount of money that is involved, the amount of trade that's involved. the amount of revenue that's coming into the government, that government officials have said that they might have to refund if these tariffs are found to be illegal. And it also is going to serve as a big test for the sort of conservative leaning portion of the court who have historically, for the last number of years, pushed back a lot on broad claims of executive power by administrative agencies to read, a lot into given statutes. They did things in the last few years like overturning deference to executive agencies on the interpretation of statutes. They've developed something that they've called the major questions doctrine, which is this idea that Congress has to be specific in some fashion when an administrative agency is supposed to be exercising, a large amount of power over major questions of like political or economic significance. This came up during the Biden administration in the student loan case. It also came up in West Virginia v. EPA, which was the spawn of it, about regulation of greenhouse gas emissions. So it is going to be a very important case as we see how this court is going to relate to the Trump administration and the Trump administration's push to control the executive branch, as well as to exert a lot of power over American policy without a whole lot of backing from Congress.
Yeah, this seems almost like one of these cases where Trump is doing something and having the court tell him that he can't, and kind of forcing the hand of people to challenge what he's doing in when he's doing something that hasn't been done before, particularly in an emergency stance. And I think what's interesting about this one is what it's going to say about the separation of powers and Congress's power to regulate, to do tariffs and trade. And, just how does just declaring an emergency get around that, if at all? And so a totally unanswered question. Okay, what else do you have in this Trump issues bucket?
Yeah. So the other big aspect of what we're going to see this term from the court is how much Trump is going to be able to control the executive branch. The sort of headline case for this is Trump versus Slaughter, which is a very direct challenge to the independence of, so-called independent agency board members, and just more broadly, anybody that's hired by the federal government who is supposed to have some sort of protection against arbitrary removal under federal law. There is a case from the 1930s called Humphrey's Executor versus, I believe it's FTC. It's referred to generally as Humphrey's Executor, which said that for independent agencies like the Federal Trade Commission, Congress does have the power to give them some protection from removal by the president. That has been chipped away at over the years by a number of Supreme Court decisions. And then Trump, too, came into office and then started firing a lot of people wholesale who, prior to Trump, too, a lot of folks considered to have protections from being removed. Things like National Labor Relations Board members, Consumer Product Safety Commission, FTC, as I mentioned, including Federal Reserve members, that is really changing the paradigm about how much control the president has over who is staffing the executive branch and who's working on the president's behalf. There have been a number of decisions by the current court leading up to this moment that sort of set the stage for it. There was a decision several years ago in the first Trump administration about who could lead the Consumer Financial Protection Bureau. There was a decision in the Biden administration about replacing the head of the Social Security Administration. And now there is this slew of firings in the second Trump administration, getting rid of a lot of people, who, despite the fact that they have written into the law protection against being fired, except for some sort of cause. And this case, Trump versus Slaughter, is really going to determine what the new landscape is for that amount of executive branch control. The court has already sort of sent some signals here because they preliminarily allowed Trump to fire Rebecca Slaughter and all of these other officials while they consider the case, while the case works its way through the court. The only exception to this has been Cook, who is the Federal Reserve member who the conservative majority of the court has, in one concurring opinion in one of these emergency cases, said the Federal Reserve is different from all of these other people who have firing protections. We might consider it differently if it comes to us. So keep an eye out for both the Slaughter case and the Cook case over the Federal Reserve as they move their way forward.
And has that been set for argument yet? And when is that?
It has been accepted, but it has not been set for argument yet. We only have the argument calendar through October and November. They've not announced December or anything later yet.
In that case, is it essentially turning, as I understand it, I think it's essentially turning on what counts as an executive function and how much the agency is doing something that is considered something that the president should have control over, and therefore should be able to fire somebody if they're doing things that he doesn't approve of in a way he doesn't approve of. Is that right?
Yes. And the argument from the other side is that, Congress intended to create these independent agencies, and that the court has very broad interpretations of what executive power is, and how much power the president should have over firing people that were meant to be set up as separate by Congress. But the president still has the opportunity to nominate these people who are confirmed by the Senate to these positions. So there is still some involvement of the president in the creation of these positions and the staffing of these positions. But the Trump administration's argument is that they have to have the at the moment ability to fire someone, not just the power to nominate and have them confirmed.
All right, let me just pause and say, remind everybody that there is a Q&A box at the bottom, and you can ask us any questions if you didn't feel like we covered any of these cases and any question that you had about these cases, feel free to fire away. But then let's move on then to the election cases, because I know that this is a big deal, especially the redistricting being such a big issue now as Texas and California and other states mull the idea of Missouri, I guess, did it mull the idea of redistricting here before the midterms. So I think the big one is the Louisiana case. What's the issue there? What's at stake, and when are they going to hear that?
Yeah, so this is actually a holdover from last term. They took this case, heard argument, and punted. And over the summer, initially this was a dispute over whether Louisiana's second version of its congressional map, which had two minority opportunity districts in order to comply with the Voting Rights Act, whether that map also violated the 14th Amendment for allegedly racial gerrymandering. A lower court found that it did. It went up to the Supreme Court, and the case was argued. And the Supreme Court didn't decide anything. Now, over the summer, they issued a new set of questions presented, which asked pretty straightforwardly whether districts that are drawn to create, minority opportunity districts violate the 14th Amendment. And this goes into very quickly, a lot of experts have said, goes into sort of the survival and viability of Section 2 of the Voting Rights Act, which deals with minority opportunity in voting and voting districts in particular. And there are nationwide dozens of districts that have been created pursuant to the Voting Rights Act, where minority voters, whether it's Black, Hispanic, or Latino, Asian, have an opportunity to elect a candidate of their choice. That's due to amendments to the Voting Rights Act, 1982 onwards. And a key aspect of that is what's called vote dilution claims, the idea that legislators or anybody else, when they're drawing districts, was diluting the power of certain blocks of voters that would otherwise, vote together and elect candidates of their choice. That is what resulted in the court claims that created the second Louisiana map that is in dispute right now because the state has 6 members of Congress. The state is about 1/3 Black voting age population. And the argument was that the state, when it drew only one Black opportunity district, was diluting the power of Black voters otherwise. After a court fight, Louisiana legislators drew the second map, and the second map, which has the second Black opportunity district, the second district is kind of snaking its way through the state, sort of picking up a bunch of Black majority communities along the way. The argument that the legislature made initially was that they were doing that for political reasons to protect the districts of Julia Letlow and Speaker Mike Johnson. But now that the case has turned towards sort of the collision of the Voting Rights Act and the 14th Amendment, Louisiana is not so fervently defending the map. And the DOJ actually has weighed in now, urging the court to sort of go away with the post-1982 vote dilution claim reality, and arguing that race should not be allowed to be sort of a primacy in drawing districts. Basically, the takeaway that I've got from experts, talking to experts in this, is depending on how the court rules, it could result in new maps in Louisiana. It could also result in a lot of minority districts across the country being subject to lawsuits or otherwise losing their legal protections, so that they could be open to mid-decade redistricting, by a opportunistic legislature, one way or another, trying to maximize sort of partisan gains. This is going to be a huge case for how district lines get drawn in the future, and it is going to be very, very important. Maybe not necessarily for 2026, the midterms, because it's going to be kind of cutting it close to get new maps in place before then, but certainly for 2028 and beyond.
Right. This is not the Supreme Court's first take at the Voting Rights Act, and it has been cutting back the Voting Rights Act in decisions for more than a decade now, I think. So it is an interesting conundrum that Louisiana officials say. They're like, well, on one hand, we've got constitutional claim. On the other hand, we've got a law. One says we need to consider race. One says we can't consider race. And the Supreme Court is, I think, going to be open to that argument.
Yeah, they seemed to be last time around. There was in particular, and I think an exchange that's going to be important in this time around when it's argued. Last time, Justice Kavanaugh sort of openly wondered whether Section 2 of the Voting Rights Act should have a time limit on it, similar to Section 5, which was the pre-clearance provisions that a little bit more than a decade ago the court did away with, saying that they were unconstitutional. And I would not be surprised to see a similar argument emerge, that Section 2 should otherwise be time limited. That was hinted at as well in the DOJ brief and other briefs that have come in the case. So this is going to be a very big deal.
Right. And then there's 2 other election cases, which I think are it's a big election year at the Supreme Court. So what's the next one that you're looking at in politics land?
Yes. So the next sort of biggest one is the NRSC versus Federal Election Commission. And this is a very direct challenge to the limits on coordinated party spending, which is spending that parties are allowed to do in coordination with political candidates. The argument here is that those limits run afoul of the First Amendment for limiting speech that would otherwise go to supporting political candidates, which is a very core First Amendment speech that this court has routinely ruled in favor of. Even the circuit court that upheld these limits noted that they were, these limits were in tension with the prior Supreme Court rulings against campaign spending limits. This is the same court that had, Citizens United ruling a few years ago. in the last few years, they've also ruled against limits on loans in candidate campaigns, things like that. This is a court that has routinely ruled against campaign finance and campaign spending limits.
Right.
Uh,
Okay. And what's the next one? Well, I think there's the third of three. What's the next one?
yes, yes. So this is the third of three is Boast versus Illinois Board of Elections. I apologize if I got the pronunciation wrong there. This is it sounds like a procedural dispute. It is a procedural dispute, but it is the kind of thing that's going to set the stage for potentially a lot of fights down the road. So Illinois allows mail-in ballots that arrive after Election Day to be counted for the purposes of federal elections. Mike Boast challenged that, arguing that federal law sets Election Day as Election Day. And the issue is over whether Boast can challenge that whole thing. And basically, what could happen here is if the court allows that challenge, saying that this challenge can proceed, that could set the stage for a lot of post-election day litigation challenging the counting of ballots, a la what we saw post 2020. And sort of lay the groundwork for a lot of court fights over absentee and mail-in ballots, especially in close, tight races. And right now, there has been a lot of litigation sort of at the edges of this issue, but this is the first time that the Supreme Court has directly taken up who can fight over what ballot counting happens after Election Day. There's also been some legislation proposed on this that would limit the use of post-Election Day counting for federal elections.
Right. Thank you. And we do have a couple questions. I think I'll throw these out there now to you. Is the Humphreys executor case narrowly on independent agencies, or is it broader, giving the president power to fire any and all staff working in the executive branch?
So it is pretty narrow on independent agencies, but there is the fact that however the court rules is likely to be used very broadly by this administration. And also, given what the court has said about their Social Security decision, in particular in the other emergency cases, I'm thinking about like removal of independent count. What the courts have said, sorry, about the Social Security case, which was the prior case in this sort of line. It's likely to be used very broadly in terms of the firing and removal of other officials, depending on how the court comes down. But the court only takes so many cases a year. This case is likely to be used very broadly, however it comes down.
All right. The next question is regarding the court's decision in the shadow docket to leave many of the federal employee firings intact while it considers the merits of those firings. Presumably, those employees will have moved on with their lives, gotten other jobs. So what relief could they hope for if the court reverses their firings, however unlikely?
Yeah. So there is the remedy in these cases is still actually up in the air. The famous one that I mentioned previously, the reason why it was called Humphrey's executor is because Humphrey, the person who was the FTC commissioner who was fired, actually died in the pendency of the lawsuit. So his family got back pay for the period of time that he should have been commissioner and was unjustly fired. So back pay is a thing that's been brought up. Reinstatement is a thing that has been brought up, things like that. And that is also the kind of question that might be answered by how the court rules in the Slaughter case.
Yeah, thanks. And I do think that's a good question in terms of the broader discussion about the emergency docket and how it is increasingly being used to shape American law. We can talk about that later, but essentially it's what the five people at the court say should happen in this case while the case is pending. A lot of times is sort of most of the ball game on terms of that. So thank you for the question. Let's move on then to the third bucket, which I think is the culture war cases. So what have we got on tap there?
Yeah, so two of the big cases here are the West Virginia and Ohio cases about the participation of transgender uh, athletes in girls' sports. They are challenging state laws and rules that bar the participation of transgender girls in girls' sports in West Virginia in sort of primary school, middle school, high school, and Idaho as it relates to colleges. These cases are about whether the sex discrimination that's present in segregating sports by sex is permissible under the Constitution. And this is going to be very interesting to see because just last term, the court kind of dodged this question in the gender affirming treatment case by sort of turning to medical regulation and that sort of frame of looking at things. They might not be able to avoid this question here in this case, or sorry, in these two cases. They involve both Title IX of the Civil Rights Act and the Equal Protection Clause under the 14th Amendment to the Constitution. So this is going to be very interesting to see how they shake out. About half the states in the country have some sort of limit on transgender girls participating in girls' sports. This has been attempted to be done through executive order by the Trump administration. The House has passed legislation to this same effect. There is riders on spending bills that would nationalize this policy, prohibiting any Department of Education funds to go to any school program that allows this, things like that. So how the court comes down on this could impact, both state law, federal policy, spending policy, all of this stuff. In addition to the fact that this is a very hot button issue, this was a major issue in the 2024 campaign. And there is a lot of rhetoric around this that is very publicly going to play out at the Supreme Court. The other big case so far on LGBT rights is this is another civil rights case out of Colorado. This is Colorado's ban on so-called conversion therapy, the idea that in talk therapy, you are not allowed to try and convince someone not to express their LGBT identity, whether that's not transitioning or not living as they identify in their sexuality. The therapist who has challenged this makes a First Amendment challenge, saying that they want to be able to provide therapy that does not comply with this law. There's been a number of cases around things like this, particularly around the LGBT community. There was a prior case called 303 Creative v. Elenis that was about offering the creation of wedding websites for same-sex couples, things like that. And the court signed off on a person who wanted to create websites without having to create it for LGBT couples. There was also the wedding cake case a few years ago, also out of Colorado, things like that. That there's been a lot of cases along these lines around First Amendment challenges and LGBT rights issues. There is also, I will mention, there is a challenge to the court's Obergefell decision legalizing same-sex marriage that is working its way through the cert petition briefing right now. That could, if four justices want to, that could end up on the docket this year.
Yeah. Sorry, that underscores the question I was going to ask a little bit, which was my comment on the Colorado case is that it's really interesting because it's a medical case, but the medicine in this particular instance is talking. And so it's a strange, mixture of can we regulate medical treatment because of medical malpractice, trying to avoid medical malpractice claims and all that. versus you're actually just talking and that speech. That's interesting. And then the question I was going to ask about the transgender sports case is are we going to get is this going to be the final answer on this question?
I mean, almost certainly not going to be the final answer on this question, if only because there are other cases that are working their way through the courts right now around LGBT rights, around transgender athletes' participation in sports. I mentioned earlier the Trump administration's executive actions. The executive actions around transgender athletes' participation in sports, particularly, there's an ongoing court fight in California about this issue that could continue to percolate because California law allows it, and they are continuing to fight over it. There's also things like the Trump administration has changed the passport policy around gender markers on passports, on any number of things that are going to continue working their way through the courts. The Supreme Court, if not this term, certainly in terms to come, is going to be dealing with LGBTQ and transgender issues as they percolate.
All right. And I'm going to ask an attendee question here. Do you think that the Idaho case will get excused from SCOTUS review as she has requested? And go through that request and whether
So fundamentally, the athlete at the center of the Idaho case has said, I'm 24. I'm no longer attending this college. Even if I won, couldn't be on the track team because I'm no longer attending this college, and said that suggested that the case is moot, which is basically saying how she wants to back out of the case. It's possible that they will. The experts who I've spoken to have said fundamentally the court is going to do what it wants to do. It's going to do whatever 5 justices say they want to do. The same legal issues that are involved in the Idaho case are almost exactly the same as what are involved in the West Virginia case. The Idaho case does involve colleges. It does involve just the Equal Protection Act, the Equal Protection Clause of the 14th Amendment, as opposed to also involving Title IX. So there are some differences between the two cases, and they may, for some reason or another, decide the case based on those nuances. But we don't know yet. And fundamentally, it depends on what 5 justices want to do.
Yeah, that just goes to show you a lot of times predicting what might happen is you just never know. There is an attendee question that I will ask you, and I will ask you to elaborate more on this too. What do you think the chances are that the birthright citizenship case will return to the merit docket this term? And in answering that question, is the term full? Are they going to add more cases? When might we see more cases?
So it is possible that the Supreme Court could end up hearing birthright citizenship or any number of other of these administrative law cases, or sorry, the administrative action cases for writ more broadly. It depends on how the sort of merits appeal process works out. So for instance, if the Trump administration asks for en banc consideration by the full Second or Ninth or Fourth Circuit or whoever's put the case on hold, and the en banc review is granted, that is going to take a whole lot more time than it would if the en banc review were denied, and then they could just go straight to the Supreme Court. That sort of thing that is going to, those sort of logistics, I think, are going to play a big factor in whether we see some of these cases come back to the merits docket again. And there's also, again, the possibility that the Trump administration might decide to bring an emergency application in one of these cases that could be granted for the merits docket. So it's an open question whether we see some of these cases come back on fully on their merits, not just in an emergency this term. There's also, again, the possibility that there could be more things that the Trump administration could do that could move quickly through the courts and get back up to the emergency docket again. Going off of that, there are some unanswered questions from the birthright guardianship case last year that could again make their way up in an emergency posture, not on the merits again, but on how the court is handling it, how the court is handling the injunctions, and we could again get that sort of not quite on the merits decision, but dealing with the case in some fashion. Like there could be another docket entry about birthright citizenship that's not actually about birthright citizenship this term. Basically, is what I'm saying there.
Yeah. Let me go to another. Oh, go ahead. Go ahead.
Yeah. Well, I also mentioned earlier that there have been 38 cases granted so far for 34 arguments. Some of them are joined. And there is the next batch of cases that we're going to get granted is after the long conference that is going to happen on next Monday, the 29th. We expect that there will be an order on whether or not they're going to be granting those cases and how many by Monday, October 6th. And we do expect that there are going to be at least a dozen, if not more, cases granted this term. The last 10 years, the Supreme Court has had between 47 and 81 cases in total over the course of a term. So I'm saying at least a dozen. I expect that there will be more than a dozen to get in that ballpark somewhere.
Okay, I'm gonna get to these questions from the audience here because we are running out of time. One says, has there been any signaling for how justices may rule in Childs v. Salazar, which I believe is the Colorado case? And then isn't there a case related to compelled government speech regarding transgender? Is that the Colorado conversion therapy case?
So the big case that has been brought up is conversion therapy. There, I believe, are some other First Amendment cases that are working their way through the cert stage, and there is one First Amendment case that is set fully briefed and set for the long conference. I believe that one is just religious expression. But I have not fully read everything that is on the cert docket. I believe that the big one right now is Childs v. Salazar, the Colorado case. That is going to be very interesting to look at because I mentioned 303 Creative, which was the prior case in this regard, talking about First Amendment regulation of speech around LGBT issues. And there, the court spoke out very forcefully in terms of First Amendment protections, but also in terms of the Tennessee last term on gender affirming care. They also spoke out very forcefully in terms of state authority to regulate medical practices, which are exactly what are at issue in the Colorado case. I think it is going to be very interesting to see how the justices come down in terms of the limits of state authority here, because there have been a lot of different cases in the last couple of terms where they've come out differently in terms of how far states can push compelled speech in First Amendment context.
All right, thanks. I'll go out a little more on a limb and say I think they're probably going to side with the free speech and the therapist in that case. And my editor, Jess, has appeared in this
With the hook.
Zoom to give us the hook. So thank you, everybody.
Yeah, the shepherd's hook here.
Thank you, everybody, for attending, and thank you for the questions, and I'll turn it back over to Jess.
So I would be remiss if I didn't urge those on this webinar to read roll call next week. There will be an in-depth report on looking at what Supreme Court is doing next term, written by Mike here and edited by Todd. So you're in for a treat. We are nearly out of time, and I would like to thank you guys, Todd and Mike, for sharing your insights, and to all of you for joining us today. As the Supreme Court term unfolds, we will continue to track the developments that matter most to your work. Please be sure to follow CQ and Roll Call for ongoing coverage. We will see you next time. Thank you.